Welcome to this Federal Pro presentation on Civil Service Rule 11 and Executive Order 14284. Today, we will explain what Rule 11 requires, what it changed, and what employee relations practitioners must do to comply. This is our take. You should confirm with your own research. This is not legal advice. The EO, issued on April 24, 2025, creates Rule 11. Rule 11 is found in Title V, Code of Federal Regulations, Part 11. The Office of Personnel Management issued interim guidance in April and follow-up templates and a question and answer document in August of 2025. Rule 11 revokes former Civil Service Rule 2.4. It makes Part 315, Subpart H, inoperative. It also directs future Office of Personnel Management rulemaking. Rule 11 applies to competitive service probationers and to accepted service employees in trial periods. Rule 11 does not apply to actions governed by special statutory schemes. Supervisory probation remains unchanged and separate. Competitive service probation remains 1 year. In the accepted service, the trial period is 1 year for preference eligibles and 2 years for all others. Tacking applies only when all three conditions are met. First, service in the same agency. Second, service in the same line of work. Third, a break in service that does not exceed 30 calendar days. Under the old rules, a break of more than 30 days could not be credited. Under Rule 11, the regulation now states that only one break is permitted, and it may not exceed 30 calendar days. The practical effect remains the same. The updated language removes any ambiguity. Current continuous service under Section 7511 is still 1 year. It remains independent of probation rules. It is still determined the same way as before. Due process eligibility is not affected by Rule 11. Rule 11 governs probation mechanics. 7511 determines who is an employee for Chapter 75 purposes. These are separate determinations. Employee relations must complete 2 separate analyses. First, Rule 11 coverage, including probation, trial status, and required certification. Second, 7511 status, which determines due process rights. A person may be both a probationer and entitled to due process. For probation or trial periods ending on or after July 23, 2025, a meeting is recommended 60 days prior. Certification is due 30 days prior. The agency must affirmatively certify that continued employment is in the public interest. Without certification, the employee is subject to termination. The agency must still process the termination action. Certification must state that continued employment advances the federal service. It must be signed by an authorized evaluator. It must be issued within the 30-day window. It must be processed before the anniversary date. The evaluator must be designated in writing by the agency head or designee. If certification is not issued, the employee is terminated by operation of law, as stated in Section 11.5, Paragraph A. There is no passive completion of probation. If the agency fails to process the action, the employee is still terminated by operation of law. The agency may petition the Office of Personnel Management for reinstatement, but only for limited reasons. If the agency intended to retain the employee but failed to certify, it may petition the Office of Personnel Management within 30 days. This authority is discretionary. The Office of Personnel Management may or may not grant the petition. The regulation is silent on back pay. Examples of administrative error include a certification completed but not filed, a human resources processing delay, an incorrect evaluator designation, or a system failure such as missing alerts. The following do not qualify as administrative error: a supervisor forgetting to evaluate, an intentional non-decision, avoiding performance issues, or stating that the office was too busy. The agency must notify the employee in writing. The agency does not need to provide reasons. Only the effective date must be included. Rule 11 eliminates the former requirement to provide a written statement of reasons. It removes prior due process requirements related to pre-appointment issues. It eliminates the old presumption of retention absent agency action. Rule 11 removes MSPB jurisdiction for employees covered by the new rule. Employees appointed on or after April 24, 2025 have no Merit Systems Protection Board appeal rights under Section 11.6, Paragraph A, other than whistleblower and the like. Employees appointed before that date may attempt to file an appeal as previously allowed. Probationary employees still retain other avenues. They may file equal employment opportunity complaints. They may file USERRA claims. They may file whistleblower complaints through the Office of Special Counsel, and they may pursue reduction in force rights, which remain unchanged. The most significant change under Rule 11 is this: no certification means termination. This outcome applies regardless of performance, supervisory intent, the underlying reason, or any processing issue. Rule 11 also sets a new timing rule. Without certification, the employee is terminated the day before the anniversary date of appointment. This occurs by operation of law, not agency discretion. Agencies should rely on a consistent workflow. Please take a moment to like and subscribe if you find this helpful. The 60-day check-in is required. Its purpose is to discuss readiness for retention and to begin any necessary documentation. The 30-day certification window requires the following. Certification must be completed within 30 days before the anniversary date. It must contain an affirmative statement. It must be signed by the evaluator, and it must be filed and processed in a timely manner. If the agency intends to certify, it must verify the public interest criteria, optionally use the Office of Personnel Management template, obtain supervisory input, and record the retention decision. If the agency is not certifying, it must provide written notice of the termination date. No reason is required. There are no reply rights. The agency must coordinate with information technology and human resources. If the supervisor takes no action, termination still occurs automatically by operation of law. Human resources must then process the paperwork retroactively to effectuate the separation. If the agency intended to retain the employee but failed to certify, it may submit a reinstatement petition to the Office of Personnel Management within 30 days. This option is available only when there has been an administrative error. A failure to certify scenario typically involves a supervisor forgetting to complete the certification. The outcome is termination the day before the anniversary. The agency must then process the action retroactively. The key issue is that inaction equals separation. Additional considerations include debt collection and the Office of Personnel Management guidance, indicating the employee may remain in a duty status while a petition is pending, although many operational questions remain. A common pitfall is assuming that no action equals retention. That is no longer true. Without certification, termination occurs by law. Another pitfall is assuming that a 30-day break in service restarts probation. That is incorrect. A break of exactly 30 days is creditable. A third pitfall is using first-line supervisors as evaluators. The Office of Personnel Management discourages this. At least a second-line official is recommended, with senior executive service preferred. A fourth pitfall is overlooking mislabeled appointments. Probation must be tied to the initial appointment. Mislabeling leads to errors in determining coverage under Rule 11. A fifth pitfall is missing the 60-day meeting. This meeting is required and affects both planning and documentation. Key points to remember are the following. No certification results in termination. The effect is automatic under law. The evaluator must be properly designated. The public interest standard is broad. Only administrative error allows a reinstatement petition. Current continuous service rules are unchanged, and employee relations should always verify the appointment type and due process entitlement, regardless of probationary status. Thank you for joining us today. This is our take and understanding of the new rules. You are responsible for your own understanding. Please like, subscribe, comment, and share.